Hi, Arabella.
Hi. Oops. How are we?
Surviving.
Good? Yep, I feel that. Absolutely. Seeing nods. I think it's the time of year, guys.
How are you going up there, Arabella?
Um, I'm safe and well, and so are my family, so I'm very lucky. But it's been a week, I'll say, Angela. It's been a week.
Yep.
Um, yeah, so yeah, the flooding around the Cairns region was quite um
Insane,
catastrophic,
really.
really. Yeah, yeah.
Yep.
So as a Cairns local, it was quite a shock,
Mm.
just for that to happen in my neighborhood. But the rains have stopped. It's a blue sky, so hopefully all the cleanup and repair work can start.
Yep.
But yeah, it's been a week, guys. So apologies if I'm perhaps not as organized tonight. But we do have our week 5 and our week 6 to get through. I'm not anticipating that we'll have a big group tonight because week before Christmas and also assessment due on Friday. But that's fine. I've had a bit of a look through the 2 sets of tutorial questions, and we might actually be able to finish a little bit earlier. I think I'd estimated 8 o'clock, but I maybe 7:30 if we can whiz through, because I'm sure people have got assessments to do and probably Christmas shopping and a million other subjects. So we'll aim for a bit of an early finish. I do just want to kick off with some questions that I've had around the assessment, and if there's obviously anyone on the call tonight that has further questions. Just for everyone and those listening in later, just confirming how to submit your assessment. You should be able to upload your advice, your will, and your power of attorney as separate documents. The limit is 20 documents, I believe. So there shouldn't be any issues around having multiple documents submitted. I did say on the forum, I think in response to a query, if you've already done it in one document, that's fine. Submit that. You don't have to break it down. There's no issues with that from my end. And it's not going to impact your mark. So hopefully that's fine. I think there was some confusion because there was 2 submission boxes or links. There should only be one now. Um, so as far as I know, and I've had a bit of a look, you click on the submission, you can upload your 3 documents, and you shouldn't have any problems. If you do, let me know.
So, Arabella, there's a lady who's not here tonight who had uploaded, and I think she's put it on the forum as well, that she's
Okay.
actually, her documents have actually all gone, the assessment she's uploaded. So, obviously, that's the section that has been deleted um, before you've realised that there was 2 places to upload. So if people have already uploaded their assessment piece, you've got the thing to say, email to say it's all been turned in,
Mhm.
but then you've deleted that. What happens with those assessment pieces for those people?
There was only one student that
Yeah,
had submitted in the previous box
yeah.
link. Nicola did say that I can download that and resubmit it for them in the correct
Okay.
box.
And you'll make
So
contact with that student?
yeah, yeah,
Okay.
I'll
Yep.
do that.
Awesome.
I'll make a
Thanks.
note to do that. No,
Yep.
that's fine. If you're talking to them, let them know as well.
Yep. No worries.
Arabella, I have a question if you don't mind.
Yes.
Can I submit the will and letter of advice as a Word doc and the power of attorney document as a PDF?
Yeah, that should work.
All right,
Word
thank
docs,
you.
PDF. Yep. Yep.
That's how I've done it too, Luke. So
Oh,
you
good.
and I are both in the same boat.
Good to know, Bill. I'm praying for 3 high distinctions.
Excellent. So, any other questions around submissions just from people online tonight? Take silence as a no. Yep.
Hi,
Um, yes.
sorry, Arabella. I've just pulled over. I'm in my car trying to race home to get in there in
Oh,
time.
that's all right.
I do have a question, and it didn't dawn on me until I was looking at first year students' assessment for a letter of advice.
Yeah.
Because I'm past leader for that subject, and in there, I know you haven't stipulated this, but it was to do it in third party.
Your letter of advice.
Third person, sorry. Yeah, with our letter of advice, are we allowed to say, I have done this for this reason, say the power of attorney document or whatever, or do you want it so that it's not in third person?
I guess, look, most letters of advice are sort of written in the third person.
Okay. So
but
you
I also,
don't say I, yeah.
Yeah, so I don't
Yep.
say to my clients, I believe you should do X, Y, and Z. And to be fair, Kim, I actually didn't turn my mind to whether that needed to be stipulated or not. So
Yeah.
I didn't even think about that.
No, look, I will just say, like, if that is how people have drafted their correspondence, I mean, that's okay. I'm not going to mark you down if you've said I suggest this, etc., etc. So that's fine. I'll put a note up so everyone knows. But ordinarily, you write in third person. But you know what? To be fair, some solicitors take a different view on that. But for our purposes, I think third person is more appropriate.
Okay. Yeah, and it only made me think because it is a will, and it is like all other letter of advices I've done, and in assignments, and even like our take-home papers, I've done it, third person. So yeah, okay.
Yeah. Well, look, hopefully, if that's what has been taught, and that seems to be the case, that's how most students will have drafted, hopefully.
Okay.
Yeah.
And last thing from me as far as the assessment goes is I know you've said it's okay to do one document, but I've managed to scan each page of the enduring power of attorney. I typed it up on there and then scanned it into the document. So it'll all come in as one Word doc, but it's all in one document. Yeah.
Yeah, that's fine, Kim. Yeah, no worries at all.
Thank you.
All fine. Great. Any other quick questions from the floor? No. Just confirming. So again, everyone has access to the same information. The usual. I've had some questions about buffers, 10% buffers. The usual buffers apply. So 10% over, 10% under. I've put that in the forum as well. There was a question around signing off because we don't know the name of the managing partner. By all means, use your own name, make up a name. That's fine. I'm not concerned. You can simply write managing partner, also fine. I think that they were the main issues that people have raised. I did get a question. Just going to check if she's online. No. Oh, Ella, yes. Ella had a quick question about referencing the capacity guidelines, I think, Ella, off the top of my head. Saw that come through.
It was the explanatory guidelines for the EPA.
Yeah.
Very difficult to reference. I just put Form 9, whatever.
Did you? Yeah, I was thinking the same thing. I was having a look at AGLC.
Yeah, I think that's fine. If there's definition, the only thing I'd say is if there are definitions in legislation, use those. But if you're referencing the guide itself, that's fine too. Just write Form 9.
Okay, cool. Thanks.
Yeah, sorry. I saw your email and I thought that's probably something useful for everyone. I think they're all the questions that have come to me. Just briefly, I have had a number of extension requests, a few more than I was thinking. So I am getting through those. Just a reminder with your extension requests, if you haven't had to submit them before or it's been a while, if you do need to attach supporting evidence to your request, and that is either documents, a medical certificate, or documents that sort of correspond with your reason for needing the extension. If you if you need an extension, send it through as soon as possible. I'll work through those probably tonight or first thing tomorrow morning, but make sure that you do have supporting evidence so that I don't need to ask for that. If you don't have any evidence, physical evidence, you do need to complete a statutory declaration, which I think people are aware of, but if not, that's what the university needs. That's not what I'm imposing. That's what the university needs for me to approve it. And I can only approve extensions up to 2 weeks, 14 days. So just keep that in mind. But as I said, I'll be looking at those tonight or first thing tomorrow morning. I know that some students have been impacted by the flooding. So I know that there are some extensions needed, and that's fine. But the sooner the better if you still need them. Cool. All right, guys. Any other questions about the assignment before we perhaps jump into week 5's tutorial questions?
Arabella, one more.
Yeah, that's okay.
And then I'll leave you alone. With the will document, when
Yeah.
we're doing the will, obviously there's no word count on that, is there? It's only the
No.
letter of the advice. I'm correct, aren't I?
That's correct.
Yeah,
Yes.
cool.
Yeah.
All right. Thank you.
Cool. All right. So week 5 was construction. Construction, I think, as I said in the intro, it's quite a difficult area. It's an area of law which solicitors would typically get counsel's advice and work quite closely with counsel and senior practitioners. So it's a tricky area. It's quite interesting though, and there is some good sort of case law out and about if you have had the opportunity to have a look. So if we start off then with our tutorial 5 questions. Question 1, the role of the Court of Construction, and how is this different to the Court of Probate? Who wants to kick us off?
I will, if you like.
Thank you, Bill.
The role of the Court of Construction is to examine the written contents of the will after it has been admitted to probate in order to discover the intention of the testator. That was taken from the study guide anyway. So
Yep.
The role of the Court of Probate is to determine the validity of a will by way of examining the document that is purported to be a will, determining the testamentary capacity of the testator, determining whether the document is of improper form, and whether the will is the last will of the testator.
Yep.
Full stop.
Great. And look, that's a nice, neat summary that Bill's given us. Court of Probate is looking at basically validity issues. Is this a valid will? The Court of Construction is looking at the contents and the testator's intention. So 2 very different purposes, and obviously a court isn't going to consider the construction of a will if it's not satisfied that the will is in fact a valid will. Any questions around that? Fairly straightforward, I think. Yep. All right, which sections of the Succession Act deal with residuary clauses? And how would you describe a residuary clause to someone not studying succession law? A few questions here, and why are they important? Now, I'd normally go straight to Bill for a reference to a section, but he's already given us a good answer. So who wants to jump in here?
Is it section 33O and 33P?
Yep. All right, so let's bring those up. Or if someone has those in front of them, which I do not. Okay, so 33O, disposition of real estate or personal estate. So a disposition of all or the residue of the estate of a testator that refers only to the real estate of the testator or only to the personal estate of the testator must be interpreted as referring to both the real and personal estate of the testator. Great. And 33P, if a part of a disposition in fractional parts of all or the residue of the testator's estate fails, the part that fails passes to the part that does not fail. And if there is more than one part that does not fail, to all of those parts proportionately. Great. So 33P really is a catch-all clause, and it's particularly useful in circumstances where perhaps the drafting of the will hasn't been done carefully in an effort to avoid intestacy, which we'll come to shortly. 33P, it's a little bit of a mouthful, but if you read through it, I think you generally get the gist that you're basically catching a gift that fails and sharing it between the gifts that haven't failed. So you're not left with a share that's got nowhere to go, ultimately. And if it's got nowhere to go, it may be distributed pursuant to the intestacy provisions. So your residuary clauses, why are they so important? Sort of already touched on it, but why are residuary clauses so important?
To prevent intestacy would be the first one.
Yep. Yeah. That's one of your key reasons why having a residuary clause is so important. Any other reasons why perhaps?
Isn't it for the effective disposition of the property?
Sorry, Bill, what was that?
It assists the court of construction in the effective disposition of the property.
Yep. So again, you're catching everything that perhaps hasn't been identified by the testator. Yep. Any other thoughts that people have?
I just thought, like, just on a very practical level, like, people buy and acquire new things all the time, and it's not very practical if every single time you buy something expensive you're going in and like amending your will. So I suppose it just gives that little bit of peace of mind that if down the track you get a new car or something happens in your life, it's just giving you that peace of mind that, look, this document will hopefully still function in some capacity.
Yeah, awesome, Talitha. And exactly, if we're looking at it from a purely practical perspective, you don't want to have to be amending your will every single time your asset pool changes, because quite often your assets may change, but how you want to deal with your estate may not. So from a very practical perspective, residuary clause gives a degree of longevity to your will and your estate plan in general. Awesome. Great. Any other thoughts? I think we've got the key points that I wanted us to cover off on, but any other thoughts on the importance of a residuary clause? No, that's absolutely fine. And maybe we've touched on this to some degree, but has anyone come up with a particularly good way that they describe a residuary clause to someone not studying, or if someone came to you and said, what is this residuary clause? Explain it to me.
Basically that it just covers everything else that isn't basically, described or identified to go to a particular person.
Yep.
This is just basically divided in shares, between 3 people, 5 people, equally.
Yep. Great, Emma. Nice and straightforward. Anyone else want to share their definition? Or we're all sort of on the same wavelength there. Yep, seeing some nods. Oh, I'll check the chat quickly as well. Sorry. good. Excellent. All right. Question number 3 then. It is common for disputes to arise in relation to who is a child of a deceased person. How relevant is paternity to ascertaining whether or not someone is a child of the deceased? Explain. All right. So do we think it's or does anyone have any experience with disputes or issues arising with the issue of whether or not someone is a child in practice, or have they experienced it themselves?
I don't have a I guess it happens a lot in where we work, but I was just going to say that paternity doesn't necessarily have it doesn't play a big role in it, because you can be, the act determines that you can be a stepchild and still be considered a child. So I guess it happens. It's so people don't understand that, you know, their stepchildren can basically come after their estate if they don't leave something to them in their will.
Yeah. So I think the first point to make too is that child has a different definition depending on which sections of the Act that you're looking at, number one. What Ella's referring to is when a person is looking to bring a claim for further provision. So we're looking at section 40, 41 of the Act, because child include the definition of child for the purposes of that part includes stepchild. Now, as you know, now that we've covered week 6, what we also know is, though, that for the purposes of intestacy, child doesn't include stepchildren. So you've got 2 conflicting definitions within the same Act. Now, to answer the second part, how relevant is paternity? To a degree, not particularly important, as Ella's already pointed out. How do we treat adopted children? What do we know about adopted children in the Act?
They're actually treated the same as normal children or legitimate children.
Mm-hmm. So if I've adopted a child, that child will be considered the same as a biological child. Yep. And what happens though if I've given a child away for adoption? I know that's not the most eloquent way of saying it, but can that child still come and have a go at my will?
Aren't their adoptive parents the ones that are responsible for passing down in their will?
Yep, that's right. So the Statuses of Children Act sets this out. So the adoptive parents basically take on responsibility for that child, and the relationship between the biological parent and that child is severed, as are any rights with respect to inheritance. So where in practice things can get a little bit murky is if an adoption hasn't been sort of legally formalized, because arguably that child would have recourse to the biological parents' estate. It's rare, but it does happen. Just by way of an example, and I don't think I've shared this one yet. I can't recall, but we had a matter where our client grew up believing her mum and dad were her mum and dad. Her father passed away. Mum was unwell. Found out that she was adopted. Looked into it a little bit further. Requested a copy of her birth certificate, but mum and dad weren't listed on the birth certificate. Her biological parents were still named, And long story short, a little bit convoluted, but she had been given away at birth for £5. It was never spoken about again. The baby, her biological mother gave birth and gave her to the nurse who took her as her own. But there was no legal paperwork completed to formalise that adoption. So when biological mum died, our client had established a relationship with her for a number of years. So nice story in that she reconnected, found her biological mother, but she actually had a claim on biological mum's estate. So it happens, very rare, but it does happen, that parental right was still there. Yeah, anyway, a little bit of an interesting matter, that one. So
that they wouldn't, that she could go back to the biological mother and claim part of that estate, but if the paperwork wasn't done properly, the current adoptive parent, she couldn't claim part of that unless it was fixed up after that. Yeah, so you can't really bite at two parts of the cherry.
No. Okay. It's interesting though, because so this was in Queensland, if this was potentially in Victoria, so we're looking now at the family provision provisions of the Act. If this was in Victoria, their class of eligible applicant is broader, and a child that believes that the person is their parent can apply. So it could have gone a little bit differently in Victoria, but certainly in Queensland, she could only really have one bite of the cherry, so to speak. Yeah. Harry, got your hand up?
Yeah, just for definitions, child, you got section 40 of the Succession Act, which means child means in relation to a deceased person, any child, stepchild, or adopted child of that person.
Yep.
For that section.
Yeah.
So
Yeah.
And New South Wales, it's section 109, if anyone cares.
Oh, cool. There you go. New South Wales. Yeah, so we've got two different definitions of child within the Act. And paternity is not relevant because adoptive children are treated exactly the same as biological children. Any other questions in relation to the definition of child? This is sort of something to make sure you've got your head around.
I came at it also more from the perspective of not necessarily like adopted children, but more just like paternity, like I don't think I'm the father of that child that, I've been raising type thing. And from the perspective of like the Status of Child Act saying that in relation to recognition of paternity, that the court can order, you can make an application that the court order to do a paternity test, like to do a recognised procedure. So I suppose like with the difference between like intestacy and a family provision claim, like how that impacts on those two definitions of child. Like if you're technically, like if even the person who's raised you, if they do a paternity test and they're not technically your father, do you have a claim under, I'm assuming you wouldn't have a claim, I don't know whether you would have a claim under both intestacy and a provision claim, because I believe it wouldn't impact on a family provision, like that. Yeah, that's my understanding, but I'm just not too sure.
No, that's okay. And look, that's a good question. Off the top of my head, if the child is under the age of 18 and a paternity test is ordered, and let's say it's not the deceased is not the father, because the child is under the age of 18 and has been financially supported arguably by a dad, they do still have standing to bring a claim. If they're an adult though, and they don't have that relationship, arguably they won't have standing. They're not a spouse. They're not a child, and they're arguably not a dependent that within the defined class of dependents. So, trying to think if there'd be sort of another way that one could argue, but it would be very difficult in Queensland.
So in terms of construction, like if you were coming at it as the solicitor constructing a will, like I know personally there's lots of people like who are adults who their dad is not really their dad, but like for all intents and purposes has like raised them as their child and would be making a provision for them in their will. But if they're using a class terminology like my children versus naming individual beneficiaries, like, I mean, you're in that case, like, are you potentially opening yourself up as a solicitor for drafting a will provision with a class by not asking, is all of the children that you consider to be within this class actually your biological children?
Right. Have you failed in your duty to make appropriate inquiries? Is that?
Yeah, well, I guess like if knowing, like if you're dealing with people who will potentially be adults who don't have a claim to say I'm a dependent, and potentially like a will maker who intended those people to get a provision, but through whatever purposes, you know, someone might contest that will and say, well, they're not actually a child. I guess, like, to what degree are you required to ask these like really personal questions of people?
You absolutely are. I will say you absolutely are. Look, best practice. I can give you best practice, and then there's the real life stuff, which sometimes happens and sometimes doesn't. But best practice is to absolutely go through. So if I said to you, Talitha, I've got 3 children, be like, okay, what are their names, dates of birth, are they adopted? You would go into that much detail. And sometimes I say to people, depending on your client, obviously, I would say to people, okay, are there any quirks or interesting things about your family that I need to know about that could come back later on? And that's usually where people might say, oh, well, Johnny's not really my son, he's my grandson, but he's raised, you know, you really do need to go into that detail. From a construction point of view, just to touch on that, if the will maker, and also I should say, putting aside any negligence or sort of failure to take proper instructions by the solicitor, if the will was drafted in such a way that it referred to, I give to my children, and you know, I had 3 children, one of them was my nephew, but my child, arguably on you could make a construction application that it was my intention that this nephew be considered a child, but it would probably be opposed. There'd be arguments either way. So you'd probably need to look at some of your extrinsic evidence potentially, you know, when the will maker was making that will, to determine sort of what the intention was. So you could, but construction applications, costly, time consuming, take proper instructions, find out, draft appropriately. Yeah, good questions though. Yeah. Sorry, Emma, I think you might have had your hand up next.
You're right. Just a quick question. So a question on top of that, of what was just said, but if you were drafting that, would you say, I leave this to my children, and then if this person wasn't actually a child but was classed as like a child, would you then just put and such by their name to make
you
sure?
Could. I mean, yeah, it would depend on, I guess, the circumstances, but yeah, that would be one way of addressing it.
Yeah. And the other question I just had quickly, in some of the readings that I've done, I noticed that there's a mention of actually keeping a strand of hair of a person that dies. in case something like paternity or something like some DNA testing needs to be done down the track. So given that paternity doesn't really matter, you know, I suppose, do you really, like, would you recommend if someone was dying, one of your loved ones, that you need to be keeping something like that in case DNA is required at some point? Because I did read it somewhere in some notes that it says
Yeah,
actually
I'm-
advised to keep a strand of hair of someone who passes in your family.
it's a very good question. I should just say paternity can be relevant depending what you're arguing as well. But just because, I guess maybe that question's not worded particularly well in that, you know, adoptive children have rights too, is sort of the point I think we're making. Do we keep strands of hair? I mean, if someone came to me and said, I'm very concerned, you know, about paternity issues, I think there's going to be a massive dispute, etc. I mean, sure, you could advise them, and I mean, if that's in the readings, I'm sure people do advise that. I would probably also try and add, if you think there's an issue, try and deal with it while everyone's still alive, if possible. And I know that's not always, we know that's not always possible, but I'd be pushing more for that. Yeah, I think you could, Emma. I think you could.
Yeah.
I don't think there's a right or wrong.
It was under death and cremation or something, and it was just
Yeah.
something that said, well, look, you can't dig up a body. It was one of the cases I read. And it's,
Yeah.
you can't dig up a body. It's actually advisable to keep a
Yeah.
strand of hair or something in case you know, something
Yeah.
out of the closet. But
Yeah.
it's just interesting. It's just off the cuff that I just
Yeah,
thought I'd
no, interesting. Good point. Harry, sorry, I know you've had your hand up for a while.
Yeah, that's good. Well, on the point of DNA, they can get common DNA markers from other relatives. So your cousins, if you all got if you've all got the same markers, then you know granddad's your granddad. On the point of stepchild and adopted, they're covered by the family provision application. But if it's a non-biological child that you find out later on is through paternity, could you make a claim to the will as a dependent? Because
potentially, if that child is under the age of 18.
18 and all that, yeah. But the point is, if the child's under 18 and you have been effectively raising it, knowing or not that it's your child, it is still a dependent.
Yeah, and if it's found out that that child isn't your biological child, that child does still then have standing as a dependent to bring a claim. Yeah, that's right. Absolutely.
Arabella,
yes.
There's been a lot of, I guess, because of all the blended families over the last decades, now quite common, and where you do see a lot of children coming in. What about where there's cases, and I know of many cases where there are estranged children and then all of a sudden they're coming back in to make contact with a parent, and that leaves that open. If they're, say, maternal father passes away, that then leaves that open for them to make family provision claims against the stepmother, even if they haven't lived with that family. Is that correct? Or
Yeah.
has
So a child, including a stepchild, will always have a right to bring a claim. They're a considered class of eligible applicant. We'll come to this later, but just briefly, just because you have standing to bring a claim doesn't mean that your claim will be successful, nor does it mean that you actually have a need for further provision. So you might be a child, you could bring a claim on your stepmother's estate, but if you're in a very good financial position, you've had no relationship with your stepmom, you had no relationship with your biological father perhaps, it will be very difficult to demonstrate to the court you have a need for provision and that you haven't adequately been provided for. So estranged
So,
children.
so even if they're adults, though.
Yep.
Okay.
Yeah. So this is really good discussion, and it will definitely help when we reach, I think, I want to say week 11 or 10, family provision applications. We've got a whole week on it. But adult children, so children, stepchildren, any children will always have a right, will always have standing to bring a family provision claim. They don't have to be minors. Only dependent, a child that isn't a biological child, so a child under the age of 18 must be a dependent. So if you're interested, have a look through the provisions dealing with your family provision and the definitions, and you'll see exactly who can make a claim, and it'll be in, I think, that unit's study notes, study guide as well. Yeah.
Okay, thank you.
No worries. Harry, you've popped something in the chat. Yep. So Harry's just popped in the chat the matters that the court will consider for the family provision applications. So, yep. Cool. Julie, you've popped a question. Do you just want to elaborate on that for me? It says, is it about the relationship and dependency between the child and the parent carer? Sorry, I think I might have been talking and you popped that in and I missed it.
Yeah, I was just saying, isn't it, at the end of the day, isn't it really about the relationship that the child has with the parent, that they're not estranged, and that they have some sort of dependency or relationship with the parent? I was just trying to simplify it, to be honest. That's how I do it in my head. But
yeah, and look, that is absolutely correct. The relationship is very important, but sometimes the applicant's moral claim needs to be taken into account as well. But for another week, I think, everyone. All right. So question number 4, just because we're moving very quickly at the moment. Sorry. On top of a cyclone, I got a flu. When will extrinsic evidence be considered by the court? Okay, so we've got an application for construction. When is the court going to consider extrinsic evidence?
When they're unclear of the intention. So it's really, I guess, about statutory interpretation there with the extrinsic material.
Yep.
I think there's two cases where they will consider it. Firstly, the armchair rule.
Yep.
Where they are really using it to comprehend references in the will.
Yep.
So they basically place themselves in the position of the testator at the time of execution. And that could be things like evidence of the people they're referring to in the will and the facts that they knew at the time that they executed their will, or things like their beliefs and habits and whatnot. That would help to kind of interpret things that they're saying. But that only applies when the words of the will are unclear. And if there's no sort of unclear words, there will be no evidence needed. And then if it's more to do with the expressed intention, then they can then also admit evidence of the actual intention of the testator.
And that has to be vague, so equivocal. So the intention needs to be not very clear. Perfect. Awesome. Talitha, that's great. Really good summaries. Has anyone got anything to add to those summaries?
I just read in some of the cases that, they really try and limit going to the extrinsic evidence, because it's really about reading the words that are contained within the actual document itself and the true meaning. So having read a couple of the cases that were actually listed in this week's thing, it just really talks to sticking to just what's in the words as it is. Yeah.
Awesome, Emma. No, that's great. Well, that's a really good segue into our last question. And Emma, I hope you don't mind if I perhaps call on you. Did you do any summaries of the cases that you might want to share with us?
No, I didn't really do any
that's
summary,
okay.
but I've been reading all the cases each week.
Yeah.
Yeah, they've just been really interesting. I've even gotten onto the death and cremation ones, and
Yeah, oh, good. Yeah.
quite short, which is really good. Like they're really short little cases, most of them, like maybe 15 pages max, some of them, but the rest are like only 5 or 8, and they're really good little read. But no, I can't say I took extensive notes, but I did read them.
No, that's fine. Sorry. No, didn't mean to put you on the spot or anything. So look, I will admit I haven't had the opportunity to prepare these myself, but I can provide some after the fact if people haven't had the opportunity. But has anyone been able to put together some case summaries concerning construction, looking at your facts, the construction issues, how the court dealt with those issues, and the outcome?
I did. Sorry, you go, Bill.
No, you go. You go.
Oh, mine will be short. I actually did do a case, but I obviously haven't put down the name of the case. So I've just done all these details and I don't even know what name the case is about. So all I've written, because it was last week, was that the deceased prepared a will himself. He put in his will that he wanted to make several gifts of various properties and assets, but he failed to name the beneficiaries. And this court was satisfied that it was a clerical error, but it couldn't be portrayed that the will does not give effect to the testator's instructions because there was no file notes or, like, you know what I mean, like detailed notes left pertaining the deceased's instructions. So it could not be proved, you know what I mean? Like, oh my gosh, I don't even know because it's last week.
That's okay.
But the court ordered that the application was dismissed.
Yeah. So even though there was a will that contained gifts, there was no beneficiaries, and arguably the construction application couldn't proceed because there was no extrinsic evidence, I guess, for the court to examine to determine what the testator intended in making those gifts. Perhaps, not sure. But
yes, I think, yeah,
okay, good. And I think that's a very sort of good throwback, Talitha, to your question regarding, would you make notes and ask all of these questions? Yes, you would, because if this was a clerical error, names hadn't been included, at least if you've gone through the process and taken all of these notes, they could be submitted as evidence. So generally, if you ever go into down the path of preparing wills in practice, the more notes and the more detail, the better. Also, Ella, a good thing to note there is the distinction, and I know we don't have the case name, and that's completely fine, but the distinction between an application for construction and an application for rectification. Potentially, if this had just been a clerical error and perhaps a situation where, maybe that's not the best example, but let's say the same name or just a surname had been included as the beneficiary for all of these gifts, and we knew that, oh, this is actually some typos here, we really needed to include the full names perhaps, that would be a rectification application as opposed to a construction application, because it's a clerical error that needs to be corrected, not a question of interpretation and meaning, giving meaning to the will. So just something to be aware of. Bill, sorry, I think you did some case summaries. Do you want to share one with us?
Just in short, I was looking at Rose and Tompkins, and that was more about the construction error, where the couple were in a de facto relationship as joint tenants. Each had children from previous relationships, and each of them wanted their half of their joint property to be passed down to their respective children upon their death. The couple held the property as joint tenants, so what they had to do was go to the solicitor and re-register it as tenants in common. And then they were able to then structure their will, or they were meant to have joint wills pretty much. And they had to structure it in a way where the wife or the partner, the female partner, gave her half share in the property to her two sons, and the male to his three children. The way that the solicitor had drafted the document, what effectively happened was, because they were then tenants in common, she didn't have to, in her will, pass half to her husband and then the other half to her children. So what they effectively ended up with when she passed away, her two children was a quarter, and then her other half went to her half went to the husband or the partner. So the court made remarks that the solicitor had committed some drafting errors. It went to the Court of Appeal, and the Court of Appeal had to use extrinsic evidence, case notes, case files of the solicitor, just to discover the true intentions of the testator, which was to give half of her property to her sons, and then the other half, which was her husband's, she didn't have to make provisions in her will for that. So they basically inserted or made a rectification about that particular issue, and the action was brought by the two sons. So they reinserted those provisions in her will, and then the two sons were able to get half of the property.
Yep. Right. Thanks, Bill. That's a good summary of a little bit of a convoluted case, but worth a read if people have time. Angela.
Yeah, I just wanted to make a quick mention that in practice, what we would do if you were going to omit someone from a will, or you're not going to give the across the board, I guess, to those people who would maybe fall under the Provision Act, that they, or family provisions, that they would actually then do a letter to support to go with the will into the strong room, so that at least then it's covered off, so that if anything did come along later on, I don't know if this is the appropriate time to bring that up, but it is something that is used in practice in regards to if there was someone who may try to make a claim later on for what they believe they may or may not be entitled to.
Yeah, and look, that is something that a lot of solicitors do in practice, just to support their decision, or they ensure that the solicitors sort of, I guess, recorded it somewhere. Yep, absolutely.
Arabella, there was one case, the Bain and DiMarchi, which was listed in this week's notes, and I just thought I'd mention it because I did read that one, but it was interesting because you talked about you having a lot of clients that come to you that use will kits, and this guy used a will kit, and he was 50, and he basically left everything to his mother, and his mother died within 13 days of him dying. So it was like there wasn't really very clear stuff in the actual will kit. But yeah, it then became an issue because he had a de facto partner who actually had two children, and then they wanted to actually get access to it. But because he'd left it all to his mother and not to his de facto partner, Rhonda, it was very hard for it all to be broken down, because it was really intestate, because the 13 days difference between the two deaths were classed as simultaneous, you know. Needed to be the 30 days, if that makes sense. But I just thought that was an interesting one, just about a will kit. You know, people really big on trying to save money, but look at how much that's cost them to try and rectify it, when you could have just gone and paid a bit of money to get a will done.
Yeah, no, absolutely.
We had a really interesting case at work where there was an estate, and the daughter was the executor of, let's say it was her mum's, like she was the executor of her mum's estate. And then, wait, sorry, let me start that again. The husband was the executor of his wife's estate, and then the husband passed away. So the executor for the husband's, it was just so confusing. Like, it just ended up being like one executor was looking after one estate, and then one was looking after the other. Like, it was looking after both estates under a specific name, and it was just so confusing.
Yeah. Yes, when executors die midway through an administration, it's confusing and a bit challenging at times to deal with. Absolutely. Ian, have you got a question or some comments?
No, I was just going to give a case that I'd reviewed, that's all.
Oh, perfect. Wonderful.
Yeah,
Thank you. Yes.
I did a couple, but this was the better one. It was Wayne and Wayne, that WAIN, in the Queensland Supreme Court in 2009. And I always thought succession law was a bit boring, but these cases are quite interesting. And I also thought criminal law would have been the one that tested you for your ethics, but I think representing some of these people is going to push the limits. There was a story about a gentleman. He had a will. He'd met a lady, and they weren't de facto or anything, but he also had 3 children from his wife had passed away. So he made a will out, and he left everything to them in equal shares. So her in a maiden name and the 3 children. And this woman wasn't content with that, because they later got married. And so she said that she wanted the court to accept that the will had been revoked by their marriage, which meant she was the spouse and next in line for everything. So that she got everything and cut the 3 kids out. The 3 kids, it was before there was a bit of a change in the Succession Act about the revocation of marriage, because there was a section that said if they were there was a contemplation in the will that they were going to get married, and then you didn't have to revoke it. You didn't have to redo another one. So the boys argued that the fact that her name was in the will meant that he was contemplating marrying her, which didn't stand up. And she won. She got the whole lot. Yeah. And the kids missed out. So yeah, it's just greed, I think, more than anything else.
Yeah. No, thank you, Ian. Just doing a quick time check. We're at 6:58. So we've technically gone through our first week 5. Any other cases or questions? Do people want to have a break, or do we move into week 6? Thumbs up if we keep moving.
Let's just tackle week 6.
Excellent. Thank you, everyone. All right.
Yeah, let's just keep going.
Yeah. All right. Let me just bring that up. 2 seconds. Cool. All right. So it's a nice segue, because I think we've already touched on intestacy a little bit. And I think I said in the welcome this week, intestacy is something that I really want everyone to have a really good grasp on. It's another sort of fundamental, in my view, in this area of law. We need to understand the intestacy provisions. Again, there's not a great deal of content to this week. So I hope that perhaps after sort of the intense week 5, week 6 was a little bit of a reprieve. But it is still really important that we're across the intestacy provisions. Sure you've probably asked questions, but does anyone have any specific questions regarding intestacy that you'd like me to answer before we go through our questions? Nope. Beauty. All right. So the first question, we've got some scenarios. So let's work through those together. And we're working out who's going to take on intestacy. So Christy dies, leaving behind her mother, her estranged father, and her boyfriend Christian, who she met approximately 12 months ago. So we've got 3 people. The assets of her estate include bank accounts with the Commonwealth Bank, a tenant in common interest or share in a property with Christian, and superannuation with Q Super. We're told it's unclear whether or not Christy left a binding death benefit nomination, nominating a beneficiary. So what are we thinking? We've got mum, estranged father, and boyfriend of 12 months.
When you look at the definition of a de facto partner or a boyfriend, look at 32DA of the Act.
Yep, good start.
I looked at 32DA subsection or section 3, no particular finding in relation to any circumstance is to be regarded as necessary in deciding whether 2 persons are living together as a couple on a genuine domestic basis. So when you look at the definition in the Succession Act, he doesn't come under the de facto partner definition technically.
Correct.
So, and then you look at who is a person's spouse, so he doesn't come under the definition of that. So then I went to Schedule 2, Part 2, if the intestate is not survived by any spouse, subsection 2 states that where the intestate is not, correct me if I'm wrong here.
I will, yep.
Where the intestate is not survived by issue, but is survived by parents, or both by a parent or both parents, then the parents are entitled to the whole of the residuary estate, or if both parents survive in the intestate, the parents are entitled to the whole of the residuary estate in equal shares.
Yep.
Ultimately, Christie's share in the house will form part of her estate, including her bank accounts and her superannuation death benefit. And therefore, Christian only retains his share in the tenancy in common.
Yeah. Anyone have any different views? Other thoughts? No. Awesome.
When you said 32DA, what were you referring to there?
The Acts Interpretation Act.
Oh, okay, right. I'm thinking, yeah, okay, 1954 or whatever. Yeah, no, that's all good. I was just trying to think. It wasn't in the Succession Act. Yeah, all good.
Yeah. So that's right. So Christian doesn't meet the definition of a de facto spouse. They've only been in a relationship for 12 months. To fall within the definition, they need to be a minimum of 2 years ending on death. So Christian will not benefit from the estate. Doesn't matter that the father's estranged, he is entitled under the intestacy provisions. One thing I will flag with respect to the superannuation, we don't know if there's a binding nomination. What this means is Christian arguably could apply to have the superannuation paid to him, because the definition of spouse for the purposes of superannuation is not the same as the definition of spouse for the purposes of the intestacy provisions. So here, and speaking from practice, if you have a couple that have lived together for a year, they've purchased property, they're equally contributing to a household, it's quite likely that Christian will receive some, if not all, of the super. I caveat that by saying it really depends on the fund and the trustees and how they decide, and also the terms of the trust deed. There are some funds that will only pay to a nominated beneficiary, and if there is no nominated beneficiary, to the legal personal representative. If that's the case, it forms part of the estate and it goes to the parents. So
sorry, Arabella, on that though, we're all assuming that they're living together, and that is not clear with that instruction. So to go down that pathway, you would have to get clear instruction regarding that living arrangement. That could be a rental property that they've chosen to do as an investment. Like, we don't have enough information.
Yep. Good.
Arabella, just kind of off track. Do you remember that story? It was quite yeah, it was quite big actually. It was a judge that had applied. He'd had an affair, and then he left his wife briefly. He had an affair with this young girl who was in court, who was old enough to be his daughter. This was only in the last couple of yeah, and he applied for her super, and the parents were devastated because, you know, obviously because of all the dynamics surrounding that. And yeah, so that was a big contention there. Yeah.
Yeah. So it happens. And it's something to be aware of in practice as well, that just because someone isn't a spouse for the purposes of succession law, they may be a superannuation.
Yeah.
Dependent.
Yeah.
Yeah.
Can I just ask where you find that definition of a spouse for superannuation, please?
Oh, it will be in their trust deeds usually. Can I take that question on notice, Ian? I'll see if it is in some legislation, the SIS Act. Yep.
Thank you.
So just to summarise, Arabella, what you're basically saying is that if they were living together and they were sharing a house and Christian was there and they'd lived there for 12 months, even if he wasn't down as a binding nomination on the superannuation, he could apply because of their living circumstances to actually get that, access to that.
Yes.
And then whoever she did put down as a binding nomination, if it wasn't the parents and it was another friend or whatever, that person would just get it unless it was contested, wouldn't they?
If she'd nominated someone that wasn't a superannuation dependent, it's not a valid nomination. So you can't just put anyone down. So I can't put my best friend, my neighbour next door. It either has to be a spouse, a child, a financial dependent, or someone in that you're in an interdependency relationship with. I'll try and find some definitions.
But
Usually
she could
it's
have
also
to be him, Christian, if they were living together.
She could have potentially. Yep.
But even if she didn't, he still has a chance.
Yes. Yeah, that's right.
Arabella, I read somewhere that it was 3 years that you had to continually update your nomination with super. Is that correct for Queensland? Every 3 years?
Depends on the fund. So I'll say yes. So generally a binding death benefit nomination will last for a period of 3 years. There are non-lapsing binding death benefit nominations that you can prepare that won't lapse unless you change them or they're invalid. But it does depend on the fund. So that's when you really need to read the terms of the trust deed, because it will stipulate, you know, when they have to be renewed, how long they last, etc. But as a general rule, yeah, three years.
So what happens with those, not say that lapses, does that then give someone more claim if they're trying to apply and it's a lapsed one? Is that correct?
So I mean, if it's, yeah. So let's say you've done a nomination, it's lapsed, you die. The trustees will look at the nominations that you've done in the past, but they're not bound by that. So if you've nominated one child, but you've got 3 children, you don't like the other 2, just wanted the one child to receive your superannuation, that's not set in stone. The 2 others that you don't like can also apply. And the trustee, they determine how your superannuation is divided. They'll say, oh, okay, you did prepare a nomination 3 years ago that left it to one child. That's lapsed. You didn't renew it. We're going to pay it equally. So it's yeah, it doesn't, it's not binding. They may take it into consideration. They may not. They'll look at each of the eligible applicants that have applied for the super.
Okay, interesting, isn't it? Because like the general public don't know. And I think that's where succession law is quite interesting. You know, right down from will kits to everything. I mean, people just don't realize how difficult it can be or involved legally until they're obviously faced with a situation and someone's died and then it becomes an issue.
Yeah. Oh, absolutely. Look, I always say to my clients, if they're overwhelmed, you know, it's not something you do every day, dealing with an estate or drafting a will or claiming super. So, yeah, look, superannuation, I will say, it's its own game. It definitely interacts with succession, which is why I do think we need to touch on it. But it's its own beast as well. And then you've got your self-managed funds. But I guess going back to our scenario, there is no nomination in place. Christian could apply for the super, and the parents would need to apply on behalf of the estate, potentially. Excellent. All right, let's move on to our second scenario. We've got Carl. Carl dies as a result of old age. His wife, Charlene, dies 3 weeks later as a result of a broken heart and also old age. They're survived by their 2 children, Adam and Peter. Carl and Charlene did have a daughter, Agatha, who died in a ski boat accident 3 years prior, leaving a husband and 2 children of her own. Okay, so I think that's our first scenario. We've got Carl dying, Charlene dying, Adam and Peter, deceased Agatha, husband and 2 kids. Who's getting what?
Does it go in thirds and Agatha's 2 kids get equal shares on her third?
Yep. So if we're looking at Carl, Charlene hasn't survived by 30 days. So if, let's say Charlene had died 6 weeks later, arguably her estate would benefit, but here that's not the case. We've got 2 children, Adam and Peter, and a third, and pursuant to the intestacy provisions, issue of a deceased child will take that child's share. So Adam, Peter, and the 2 children will share equally 1/3 each. So the 2 kids will share in 1/3. Perfect. Good, Kaylee. Any different thoughts? Nope. Good stuff.
Was that section 36A, distribution of issues entitlement? Is that the one that you're...
Yeah, you're in your 30s, 35, 36, 37. And then we've got a little extra section. It's later discovered that Carl and Charlene had a child out of wedlock when they were 17 years old, and that this child was adopted. Is this child going to get anything? Yes or no?
We covered this before, didn't we?
Yep, we did. Seeing some shaking heads, that's right. This child has been adopted so that parental right and responsibility has been severed. So this child will not be receiving an interest in Carl's estate. The assets of the estate are the family home in Cairns held jointly and a term deposit with NAB. So the joint home, what do we think is going to happen with the joint home? Much the same, isn't it? Yep. And then the bank account. Cool.
So you're saying that'll go between the Adam and Peter get a third. Yep. And then the 2 kids will share in a third of that as well.
Yep. Beauty. All right, our last little
question on that one, sorry. If the child was in foster care or a children's home and hadn't been adopted at that stage, is that different?
yes. Yep.
So they would have a crack at it then?
Yep.
Okay, thank you.
Any other questions? Nope. All right, our last scenario, we've got Fabio. Fabio dies in a plane crash with his 21-year-old daughter, Lauren. Fabio and Lauren were on their way to see Fabio's wife, Fran, who was holidaying in Brisbane. Fabio thought it might be nice to surprise her. Sorry, some of these scenarios just make me have a little giggle. After Fabio's death, a woman approaches Fran and advises her that she is Fabio's girlfriend and is pregnant with their unborn child. What a doozy, and this happens. Fabio's estate consists of the family home in Cairns, term deposits totaling $2 million with Westpac, and a tenant in common share in a property held with his daughter in Atherton. So this is arguably a reasonably sizable estate. So with my litigator's hat on, there'd be something worth fighting for. So what do we think is going to happen? Fabio's died. We've got a wife, a 21-year-old daughter, a girlfriend, and an unborn child.
I was going to say about the unborn child. It's that. What is that clause? It's like it starts with it's EN.
Inventre-sur-mer.
Yes, that's it.
Yes.
Would that apply in this situation where there's an unborn child, and off the top of my head, it forms part of the definition of a child?
Mm-hmm. Yes,
yeah,
that's right. So a child in ventre-sur-mer, and sorry if I'm butchering this for people that I don't know, speak Latin perhaps. Child in the womb is considered a child for the purposes of the Act. So here, I mean, we'd be questioning paternity, I would, arguably. But assuming that the pregnant girlfriend or the unborn child is Fabio's, we've got Lauren and we've got a child in the womb. So we've got 2 children. What do we think about the girlfriend, or what do we want to know?
we want to prove, you know.
She meets the
Sorry.
definition.
Oh, I have a few people. Ella, I think you'd started, and then I'll come to you, Bill.
Oh, I was just going to say we have to prove that they were that they meet the definition of either a spouse or in a de facto relationship. So I guess it's hard when you say that they're girlfriend and boyfriend. Like, how do you know? You know what I mean? It's really hard. Obviously, they're not spouses, but de facto, you don't know how long they've been together. Like, if they meet the requirement.
Yep, perfect. Bill, anything to add to that?
No, I think I was just adding the same definition, well, the same remark about meeting the definition of a partner or a spouse or a...
Yep, no, absolutely. So if we did have, let's say this this girlfriend, we go through our Section 32 factors, you know, we're pretty satisfied. They've been together for 5 years. He's got a whole second life with this woman. We have 2 spouses, potentially. So what happens in that case? We've got 2 spouses, Lauren, and an unborn child.
Did Lauren die in the plane crash as well? I kind of interpreted that Lauren died, so he only had 1 child.
Fran, the wife that we're talking about, and
yes,
that's how I read it. I read it that way as well.
Yes, and Talib, this is a very good example of reading things properly. Thank you. So, so we don't have Lauren. Lauren is deceased. Very good. So we've
Unless
got,
Lauren like parachuted out of that plane, I
yes.
assume she died.
We'll ask the question, is Lauren alive? So no, Lauren, look, I think if Lauren's in a plane crash with her father, let's assume that they've both passed away, they both died. So we have one unborn child and two spouses, which makes it, I guess, a little bit.
So the two spouses would have to share the benefit, the intestacy benefit, which is the household chattels,
Yep.
the $150,000 provision, and a half of the residual estate.
Yep.
But I believe Fran could potentially make a claim on the family home. Is there some provision where if you live in that home, like she could then try and make a claim that she is entitled to that as opposed to it being a part of the residual?
Yes. And the other thing that could occur is Fran and the girlfriend could potentially come to an agreement as to how their share would be divided between them. And there is the process in the Act to follow if that happens. So a little bit more information. We need to find out a little bit more information about these people, but potentially we're seeing two spouses sharing in 150,000 household chattels and a half of the estate. This would actually be, I would love to run some litigation on this because I think this would be very interesting. And then obviously we've got the unborn child that we would want to, I guess, confirm paternity. And it's rare, but you would need to make sure that the child survived, was born and survived and is actually an eligible beneficiary. So the estate couldn't be distributed until the time the child is born. Excellent. Any other thoughts or comments, questions arising from this scenario? A little bit to this one. Fabio's been busy. There's two families potentially. Cool. All right. Look, if those online and those watching this later, if you haven't worked your way through these scenarios, I recommend that you do. And as I said, make sure that you're comfortable, using the schedule, using the sections within the Act, and you're confident with your intestacy provisions. I feel like we have covered off on this a few times, but how can intestacy be avoided? Residuary clauses, effective residuary clauses, number one.
Yeah, I was just going to say with residuary clauses as well, like making sure that if you're, giving one, like you're giving a share to one person, you're saying that if that person does not survive, then you give it to this person, because then that falls part of a partial intestacy, because
yes.
Yeah.
So with your residuary clauses, you need to include, or it's advisable to include a gift over clause, or draft your residuary clause in such a way that you're referring to, those who survive, such of the survivors will take, because as Ella said, you don't want to end up in a situation where you've drafted a will, you don't have an effective residuary clause, and there's a potential for parts of your estate, if particular beneficiaries don't survive, that those parts are dealt with on intestacy. So it's all about drafting. I hope that this is something that's coming across. You really need to be, you need to really think through what you're drafting, and look at what you're drafting from many different angles, almost to the point where you're taking it apart and then putting it back together, because poor drafting can really lead to some epic problems and some really complex litigation that's costly and time consuming. look, if you go into practice in this area, I love it. This is what I love, but I'm also dealing with people that are very upset, and often dealing with situations that could have been handled much, much better right from that drafting point when people were still alive. So there's my little rant for this evening. Now, question 3, this one was a little bit more of just some bit of interest, I guess. The intestacy provisions have been examined, and the policy paper, public policy paper, has been produced with some suggestions on how the intestacy provisions, and it also refers to the family provision side of things, but they've suggested some changes to the intestacy provisions which to a degree reflect legislation in other states, so such as Victoria, and I think there's a few provisions similar to New South Wales. So just have people had an opportunity to have a look at some of these suggestions or not? If not, that's fine. Ian's got it. It's look, this might be something that we can come back to, or if people read in their spare time and have some comments and thoughts, we can revisit in our question time. But one of the, or a few of the key changes off the top of my head, currently our intestacy provisions in our Act don't recognise cultural adoptions. So in a lot of Indigenous cultures, there are tribal adoptions whereby perhaps the auntie, someone's auntie, will become their mother, and it's not done in the legal sense, rather it's done in a customary sense. So there's been some sort of queries around what people think about introducing provisions to acknowledge tribal and customary adoptions. There's been some suggestions that the legacy amount, so the 150,000 funerary legacy gift, that should be increased. I think 500,000 off the top of my head. And also, and I think this is a good view, literally just my own view. As you would have seen in the intestacy provisions, if you've got a husband and wife and 2 kids, most people will assume that if wife dies, everything goes to husband. It's actually not the case. Husband gets 150,000 plus household chattels plus a third of the residuary estate. Kids share. One of the suggestions is that if you've got a deceased person and there's children that they share with their spouse, the children of that relationship, that rather than the residuary estate being shared between surviving spouse and kid, that it goes all to the surviving spouse, which is reflective of Victoria, I'm fairly certain. So there's a few things in there that I think would align with society's expectations, potentially, of the intestacy provisions. Just trying to think what else off the top of my head.
I was looking at 1.3.2 about spouse considerations is being given to amending the definition of a spouse of a deceased person so that A, B, C is extended to include a de facto spouse of the deceased person whose de facto relationship is subsisting at the date of death, irrespective of the length of the relationship, where there is a minor child of the relationship at the date of death. So removing that period of 2 years or 12 months.
But only in the event that there is the child. Yeah. Again, I think that's quite reflective of the Victorian legislation as well. So it is worth a look. And I will say too, actually, the document itself provides some really good definitions and references relevant to this week's work, but also relevant to the, I'm showing you off the top of my head, but the family provision week's work as well. So even if you use it perhaps as a little bit of an accompaniment to your readings and your study guide, I think it will be quite useful. With respect to the intestacy provisions, what do you guys think? Are there any things that just really jump out to you as being unjust or not aligning with, society's views, or, if you were sitting down at the dinner table, things that you think the people in your life would find odd or unusual that you feel like sharing?
If children, like say, like you said before, you think, oh, well, if the wife dies, it all goes to the husband, even though there's two children. Like if those kids are 6 and 7 years of age, obviously it doesn't really make sense that it's going to go to the children. But the lay person out there doesn't understand a lot of the importance about having a will and why this is so important. There's a lot of people that do not have wills, and there's a lot of these sorts of things that happen, particularly lower socioeconomic areas where people don't understand this. So what you're saying is, based on the intestacy rules, that husband won't get, he'll only get the 50,000 the shuttle from them. So then what happens with the money for the kids? It just gets held by on trust. Okay. And so technically, if they had reasonable assets, say they owned their home, for example, okay, and he's only entitled to 150,000, does that mean you have to refinance?
Potentially.
Yeah. So, and then money sitting there on trust for the kids that are at such a young age, when really these are the sorts of things that need to be in the public policy paper that's basically saying, well, is that really practical?
And I think the Succession Act's been reviewed, the Trust Act, the Powers of Attorney Act, they've all sort of undergone a review. And Julie's made the point too, what about the LGBTQ community, same-sex marriage and children? Is the language gender neutral? That's a good point too. I don't know if that's addressed in the paper, but I mean that is something to be considered.
But they inserted civil partners, the reference to civil partners in the Succession Act to address same-sex marriages.
I think, sorry, I jumped around a little bit, apologies. I think the Succession Act, it hasn't been reviewed in such a long time that to a degree it really is out of touch with society's expectations. And as you say, Emma, there is a degree of, I guess, misinformation, because people Google and they think they know, well, they talk to their neighbor and they think, oh, I know what I need to do or what I don't need to do. So people don't, I mean, over 50% of Australians don't have a will. So there's a lot of misinformation, and then you've got this piece of legislation that, it was done decades, it was prepared and enacted decades ago, that hasn't really kept up with society's expectations and society's norms now. So I think this paper or this review has really tried to do that. But I think there probably is some work that still needs to be done. So I'm really interested to see the commentary and the feedback that's provided, and where we actually end up eventually. So it's worth having a read, in all of your spare time studying. But it is a good resource for the family provision stuff as well.
Is there a date when we're supposed to get a response on, when they're going to have it reviewed, or whether it will be changed?
There probably is. Off the top of my head, I don't know what that date is. But I can probably find it. It would be, I think, published somewhere, because they'd need to stick to certain deadlines. Yeah.
Because if there's enough things
Yeah.
going to court that are contesting these intestacy rules as they are, like they're going to have to wake up and do something about it, you know, and that will mean possibly changing the act and, you know,
Yep.
hopefully
I
they do.
think, yeah, and I think just on that point of contesting, I think if we jump ahead to the family provision sections, I think there was a suggestion that there needs to be a particular process that's followed in the case of smaller states, and sort of a changing of the class of eligible applicants. So I'm excited to see where this ends up, because I think it will have a reasonable degree of impact on how we practice. So I think there will be some changes and some reasonably significant changes.
I was going to say, I find it so, like, one thing I was thinking is I always think about surrogacy and how does that impact intestacy as well? Like, I guess
look, surrogacy, and look, I'm not across surrogacy laws, but I would assume that if there is a contract or an agreement in place, I mean, that would impact to a degree how that child is treated. But I no doubt there's some grey area around surrogacy as well, but I'm not completely across that, Ella, so I don't know if I can add anything particularly useful.
I feel like it would be a really interesting area to look into, though. I guess surrogacy in general is, when it comes to the law, is very interesting. So I guess where it fell a part of estates and you know, intestacy and stuff would be very interesting. But
yeah. Great. Any other thoughts, comments? Do people think the intestacy provisions are good the way they are? No.
I think it's just going to be hard. Like, I do think there's definitely room for change, but you're never going to start, like, families are also different. Yes. So like every change that you make is going to open up another little thing. So I mean, that's not to say like just because it can't be perfect doesn't mean you shouldn't try. But I just think like it's never going to be perfect, because that's the whole, like, you're trying to cover so many different, or making so many assumptions about how people's families operate and what people would use money for and all of that sort of stuff. And you can never do that. So yeah, I just think it's never really going to be a substitute for having some stuff in place.
Absolutely. Yes, absolutely.
Arabella, I'm guessing once they do certain reforms and make amendments, does that have you sitting back as a practicing lawyer thinking, oh, well, that should be now changed in the will, and all the wills are past wills? You can then see potential issues because of the new amendments. Is that how you sort of sit back and look at things?
I don't think that these changes will impact, well, who knows, Kim? The answer is who really knows until we've got the legislation. But I don't think it will necessarily change the wills that have been drafted, but it may change and the approaches that we take or the strategies that we put in place moving forward. So it's really an evolving beast at this stage. But yeah, as a practitioner, when these things are sort of in the wings and you know, when legislation's enacted, it is a little bit of a guessing game at first until a few things get put before the court. But I mean, it's interesting. That's sort of one of the good things about practice. Things change, evolve, you know, move with the times. Yeah. So you there might be changes to practice, but it's not something that you're scared by. I mean, there have been cases that, particularly around solicitors' duties, for example, that have caused us to get a little bit, whoops, better like really rethink some things. But usually it's like, okay, let's work with this. How do we work with this? What can we do? What can we do for our clients? How is the court going to look at this? And we can make some sort of educated guesses around the best way forward.
Yeah. And what's your favorite part, I guess, in succession law? What's your favorite?
Oh, just like in practice generally?
Yeah, in general practice.
I quite like statutory wills. I do like a good family provision application. My background's drafting, so I haven't drafted for a while, but I did like a nice complex estate plan. But I do a lot of litigation. I also like a good complex probate application. How nerdy. Like it's all good. It's all good. And if you've got good clients and some interesting facts, it's all quite interesting.
Okay. Yeah.
We had a probate application, and it was a really difficult one because the will maker had actually made handwritten changes in pencil on their original will. So we had to make an application that basically the will is in its original form and that, it intended its original meaning. And it's so juicy. Like you think you're such a nerd, like, because the stuff's so interesting, but it is so interesting to learn about.
Yeah, I know. And you sometimes say, to your friends or your family, oh, I did this today. And like, oh, so you got like 2 pieces of paper, like rubber stamped. I'm like, yes, I did.
Yeah. And they're like, wow, that sounds so boring. And you're like,
yes.
No, but it's actually so interesting.
Yes. Anyway, I digress, but yes, very interesting area of law. Before we wrap up, give you a little bit of time back in your evening. Any questions around the intestacy provisions, assessment? I will say we break for Christmas. I think I put this in the welcome as well. We break for Christmas, and then we start back with week 7 in the week commencing 1 January, I think.
I believe we'll see you on the 3rd of January.
Yes, you will. Beauty. All right. Well, that might be a good wrap-up point, everyone. Thank you for attending and for participating as always. Look after yourselves. It's this crazy time of year. Thank you everyone that reached out during the cyclone. That was very kind of you. Have a Merry Christmas. And I look forward to seeing you all in 2024.
You too.
Crazy. Thank you.
Merry Christmas. Thank
Merry
you.
Christmas.
Thank you, everyone.
Merry
See you
Christmas.
later.
Merry Christmas, everyone.